Considering the rival submissions made on both sides and on perusal of the typed set of papers, it is seen that accused 1 to accused 3 were convicted for the offence punishable under section 353 IPC, and hence it is the duty of the prosecution to prove that PW2, who is the supervisor of the bar, is a public servant. Full stop. However, in the case on hand, the evidence of PW1 and PW2 and PW8 has clearly deposed that PW2 is only the bar supervisor and he is not a public servant. Full stop. It is pertinent to note that PW1, who is the complainant, has given go by to the earlier version. Full stop. He has gone to the extent of saying, besides admitting his signature, he does not know as to whether the complaint has been given by him. Full stop. In such circumstances, complaint and FIR are not substantial piece of evidence and that can be used for corroboration and contradiction. Full stop. Here the evidence of PW1 has not been corroborated with the averment found in Exhibit P6 within bracket complaint and Exhibit P7 within bracket FIR. In such circumstances, the evidence of PW1 has not supported the case of the prosecution even though he was not treated as hostile. Full stop. Therefore, I am of the view that there is no evidence before this court to show that PW2 is a public servant and he was assaulted or prevented by accused number 1 to accused number 3 from discharging his official duty. Full stop. Hence, the prosecution has failed to prove the ingredients of section 353 IPC beyond all reasonable doubt. Full stop. Hence, they are entitled to acquittal under section 353 IPC by giving the benefit of doubt. Full stop. Now, this court has to decide whether the conviction against the second accused under section 324 IPC is sustainable. Interrogative sign. As already stated, PW1 has given go by to the earlier version even though in the complaint it was specifically mentioned that accused number 2 assaulted him with iron scale and he has not supported the case of the prosecution during the trial. As mentioned earlier, FIR and complaint are not substantial piece of evidence and that can be used for corroboration and contradiction. Full stop. PW1 has gone to the extent of saying he does not know whether he has given a complaint, besides admitting his signature. Full stop. The complaint has been marked as Exhibit P6. Full stop. The averment in Exhibit P6 has not been corroborated by the evidence of PW1. Full stop. Hence, reliance cannot be placed on Exhibit P6. Full stop. PW2, who is the injured person, has also not supported the case of the prosecution. Full stop. In chief, he had stated that 4 persons had assaulted him. Full stop. But in his cross, in the first line, he had stated that he could not identify as to who attacked him in the mob. Full stop. PW3, who is an assistant in bar, has not spoken anything about the injury sustained by PW2. PW4 has also not supported the case. Full stop.